As a representative of your organization, you are in the process of negotiating an exciting new business deal. There's a back and forth in email correspondence between you and the party on the receiving end of those email correspondence. Of course, a written agreement hasn't been concluded as yet. There are still a few details which need to be ironed out here and there. Unfortunately, the deal doesn't work out, and the question now remains, do those negotiations constitute as a binding agreement? The short answer is, despite the informal nature of this correspondence, emails can create binding obligations. In the recent matter between Gareth Cliff and Mnet, Cliff alleged that there had been a contractual agreement in place between himself and Mnet on the basis of oral and email correspondence between the two parties. He sought to be reinstated permanently as a judge for the 2016 season of Idols and also have his termination declared unlawful and unconstitutional. The judge in the matter pointed out that the email exchanges between the two parties confirmed that there had been previous discussion regarding the 2016 season and Cliff's participation therein. The Electronic Communications and Transactions Act gives legal recognition to transactions that have been concluded electronically by email. Section 22(1) of the ECT Act expressly states that an agreement is not without legal force and effect merely because it was concluded partly or in whole by means of data messages. Even if parties are in the process of negotiating a deal, it's incorrect to assume that just because there isn't a written agreement in place, that these negotiations aren't legally binding. In the matter of Springfast Trading versus Woolbury, which concerned the cancellation of an agreement via email, the court held that the oral negotiations between the parties reduced to writing via email constituted an agreement. But how will contractually binding email correspondence be differentiated from non-binding email correspondence? The courts will look at the intention of the parties, i.e., did the parties intend to be legally bound? This can be inferred by considering the parties' conduct and words. The email correspondence in the Cliff matter showed a clear intention that Cliff would be part of the 2016 season, and the way in which Mnet conducted themselves was proof of this. In order to reduce the risk of emails being regarded as binding contracts, organizations need to specifically exclude email communications as contractually binding. One solution to this may be to include a prominent disclaimer along these lines. The provisions of Section 13 of the Electronic Communications and Transactions Act 2002 are specifically excluded unless this data message is signed using an advanced electronic signature.